Be cool, be kind, be classy. The cupcake's so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Coolness will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculousness that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning, everyone. Good morning, my friends, and welcome. Today is Wednesday, November 6th of 2024. And I'm just going to say, to start off the day, if the bickering starts in the chat, I'm just going to start singing Adele. Hello, it's me. If you don't know what that reference is, there's a Saturday Night Live skit from 8 years ago. It was a Thanksgiving skit. It was awesome. It was a family bickering about politics at Thanksgiving. And every time they would start bickering, the little girl at the table got up and hit the boombox, and everyone would stop what they were doing and say, hello. And they would all start singing Adele. And it was hilarious. Hilarious. So if you need a little comic relief today, go look for that. Just Google SNL Thanksgiving skit. Thank you, Kate. I found a little hack on TikTok today for the hair. You want to know what it is? Put your hair in a high pony. Section it into 4 pieces, 4 hot rollers. Leave them in for 10 minutes. Undo it, shake it, done. I love sharing secrets with you guys, right? Who knew? TikTok. I think it was TikTok. No, probably not, because I don't really use TikTok. So it was probably a little short on YouTube. My For You page has been changing lately to give me all of the oh yes videos, people that are dancing to those videos, and some cooking stuff. Sometimes you got to branch away. You got to branch away from the tragedy and the horror stories that we cover every single day, and find some other content. Last night I needed a little bit of distraction. So I thought, all right, let me see. I'm always watching YouTube all the time, right? Let me see what else I can find that I haven't seen. And I had started watching that Anna Kendrick dating game movie about that serial killer that was on the dating game. It's called, what's it called? It's called something, a woman. I don't know. I'll find the name for you if you want it. But it was pretty good. It was a little bit creepy. And then I was like, all right, what else should I watch that I haven't watched in a long time? I mean, that I've heard a lot about, but I haven't watched, and I didn't really know what it was about. And I started watching Baby Reindeer. By the middle of episode 1 of Baby Reindeer, I was so freaked out. I think it's called Woman of the Hour, right? Not the dating hour, Woman of the Hour. Yeah, that's it. Thanks, Cheryl. Anna Kendrick's directing debut, which I thought was great. I liked it. I liked how it gave women empowerment in the middle of these serial killer stories, which we don't see very often. So I thought that was pretty good. Anybody watch Baby Reindeer? I didn't know what I was in for. I just knew that it won a lot of Emmys because I watched the Emmys, and so I started watching it. and by the middle of episode 1, I was spun. I was like, what am I watching? And then, of course, it was like a train wreck, and I couldn't stop. And I watched episode 2, and I want to know: should I continue? Should I continue? It's a real story. Some people loved it. Good, but very dark. Charlie Lynn. Good morning, Free Karen Reed. We ain't got no quit. I heard my queen Tanis Yannetti is in the courtroom today, and I'm loving it. One day I'm gonna get Queen Tanis to come on this show. You watch. You watch. On one of my bucket list guests. VK, so yes, Baby Reindeer creeped me out. That actress was great. I think, didn't she win the Emmy? It was great. So I have the court feed up, and I have the court TV feed up because I didn't know they were broadcasting it. So we're going to see which one is better. And then we're going to go with that one. Team Brittany says, do not watch Baby Reindeer if you haven't. No, but I highly recommend 7 Seconds. Has anybody watched 7 Seconds? It's kind of old. It's an older, like, limited series. Excellent, excellent. Thank you, Beth. You're very, very funny. It is disturbing. So give us some other things that you recommend that we watch, if you don't mind. Hello, Olivia Nile in the house. The All-Stars are now arriving. I have the video source. Pretty sure I have the correct video source, Barney Rubble. But Court TV is also using it. Is also streaming it. So we'll see who's got the better camera. Barney Rubble in the house. James Lynch tuning in from Boston, Massachusetts. There's a lawsuit regarding the Netflix that it's somebody that he stole the story. I thought the guy who wrote it said that, or the guy who won all the Emmys said that it's his true story, isn't it? I don't know what the lawsuit is regarding. Some bombshell information came out yesterday in the Delphi case. For those of you who are watching the Delphi case coverage with me that I've been doing to supplement the law tubers that have been in court every day on Delphi. And it came out yesterday. There was a cell phone forensics expert who testified that Libby's phone was plugged into wired headphones between something like, don't quote me on the exact times, 5:42 p.m. and 10:30 p.m. Right, Olivia? Olivia and I have been lurking over in Andrea's chat and in Defense Diaries chat for the boots on the ground coverage. But what do you make of that, Olivia? Because I keep wanting to say Commonwealth, but it's not. The Indiana state of Indiana's. It's been a long night. The state of Indiana's theory is that the girls were killed at something like around 2:30. Let's just say, if Libby's phone was plugged into headphone jacks between 5:42 and 10:42, game over for the state on that. Richard Allen wasn't involved. Delphi closings are likely on Thursday. Yeah. Oh, Tinkerbell says the real Martha said she was never convicted of stalking like the film said. Oh my gosh. So that's her argument. I was never convicted of stalking. Not, I didn't do it. I never did it. It wasn't me. Oh, that's what it is. The lawsuit said that she'd gone to prison, but she didn't. So let's see what's going to happen with Delphi. Very, very interested in that case for the issues of law and the treatment that Richard Allen has been subjected to since his incarceration as a pretrial detainee. Maximum security prison. This is what SJC looks like, friends. We're going to hear from a full judge panel today, 7 judges. And they're likely going to be asking questions. Switch over to here so we can see the courtroom view. They're going to be asking questions of the attorneys. That's my favorite part because it kind of gives you like a window into the soul of what they're thinking. So when you're arguing in front of the appeals court, you better know your case law. There's David Yannetti all by himself. Hi, David. Hi, David. Hi, David. It looks like in front of David is Marty Weinberg. Marty Weinberg's associate. And then we have the attorneys, the appellate attorneys for the Commonwealth over here on the right of your screen. It looks like Lauren McLaughlin is there today. The courtroom is intimidating. You know, appellate lawyering is a whole another set of skills. I'm just going to mute the sound so you don't hear all that banging in the background. It's a whole different set of skills from trial lawyering because you need to be able to think on your feet. You need to know your case law. You need to be prepared to answer the questions. Who's in the gallery? Let's see. I heard that Queen Tanis is there today. Tanis Yannetti. Kelly Reed. Let's see if we can we make this bigger? Doesn't look like it. Yes, we can. Oh, yes. Oh, yes, we can. Oh, yes, we can. And there's Karen Reed on the right in the white. Bill and Janet Reed sitting to her, next to her to the left of your screen. Alan Jackson flying in for the event. Now sitting next to David Yannetti. This looks like Tanis Yannetti to me, perhaps. Front row, middle. I do not see any O'Keefes. There may be other seating behind these council tables. It may turn out that the actual court feed is better, but we will see. Right now, we want to look at the people. Their signal does not seem that great. All O'Keefes are there except for Mr. O'Keefe. Jen McCabe was not seen. Thank you, Litteros by Bettero. Oh, you saw them arriving outside? Thank you. Were you guys watching? Was Tom CPU was live outside? And apparently someone says there's seating for 100 in there, huh? This is the kind of court that runs on time. No delays, no, we're tired. No sidebars. No jury. All there. Oh, Allison, thank you so much for the $50 Venmo, who says thank you so much for covering this. Thank you, Allison, and all of you for watching. I appreciate you so much. And Justin sent a cash out before the stream started, and I appreciate you all so very much. There's nobody I'd rather spend my post-election day morning with than all of you. Hot mic. God save the Commonwealth. Good morning, Rachel. Very eager for the hearing, says Nay. Thanks, Mel. Aussie is here. Australia is watching. Shelly, thanks for becoming a new member. When will Bridget Todd be scheduled? The first time she had a sick kid. The second time, she had an emergency court appearance. The third time, I was so sick, I couldn't even get out of bed. I had a horrific 24-hour stomach bug. I'm going to get in touch with her today and we're going to reschedule it because it is not for lack of trying. That's what happens sometimes when you try and schedule streams with guests. That's why when you see like me go on with Will or something, it's always very last minute. It's like, hey, what are you doing? You want to come on? Because trying to plan things in advance gets so hard. But, you know, make sure you have notifications set because as soon as the date is set, I'm going to put it right back up. Shooting for soon. Heather Chris, not guilty. Thank you for becoming a new member. Hey, everyone. Hey, Vicky in the UK. The world is watching. Tell me where you're watching from, my guys, my cupcakes. Oh, Barbara, thanks for the $20 for coffee with the Venmo. You guys are getting in there early with the generosity. I love it. Jules, this is bringing me back to spending every day of the trial with you. Thank you for the best coverage. Thank you. I mean, I hate that we have to do it all again, but the community that we've built together is amazing. So thank you, Jules. Thanks for the 5. All rise. Me too, Nay. Me too.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston within and for the Commonwealth, draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. Court is now in session.
God save the Commonwealth.
Okay, good morning. Madam Clerk.
SJC 13663, Commonwealth versus Karen Reed.
Weinberg.
Good morning, Chief Justice, Associate Justices Martin Weinberg on behalf of the appellant Karen Reed. Today's appeal goes to the core issues regarding double jeopardy protection that safeguard defendants, in this case Ms. Reed, from the risk of re-prosecution for the very same offenses for which a prior jury was discharged without manifest necessity, without her consent, and we now know, based on the representations of 4 jurors, indirectly a 5th, no contradiction from any of the 7 or 8 other jurors, that the prior jury reached a unanimous decision to acquit Ms. Reed of 2 of the 3 charges in a multiple count indictment that she was tried on in Norfolk County. I want to first.
What is the factual basis for your assertion that the jurors who contacted the DA's office are different people from the ones who contacted yours?
I don't have.
What is your factual basis? Did you hear this? Right away with the questions. She's not even gonna, the judge is not letting him talk right away with the questions. We're gonna stop. We're gonna talk about it. Deal with it. This is Justice Wolo Hojian. Let me know you can hear this, okay?
Have a basis to.
Okay, so when you say 7 or 8, that's speculative?
The numbers are that 4 of the jurors directly contacted the defense. A 5th, there was indirect proof
Sure.
that a 5th juror contacted the defense. A juror who could have been one of the 5 or could have been one of the 7.
Okay, so you're not representing that it's more than 5?
That's correct.
Okay.
What I am contesting is that there was no manifest necessity for the mistrial, which is issue 1. There was no consent, issue 2, and that this court's jurisprudence strongly suggests that the defendant has met her burden of production and is therefore entitled to a post-trial.
People are complaining about the volume. I'm gonna go back to court TV. Tell me if you think this is better.
From the risk of re-prosecution for the very same offenses. Appeal goes.
Commonwealth versus Karen Reed.
Associate Justices Martin Weinberg on behalf of the appellant Karen Reed. Today's appeal goes to the core issues regarding double jeopardy protection that safeguard defendants, in this case Ms. Reed, from the risk of re-prosecution for the very same offenses for which a prior jury was discharged without manifest necessity, without her consent. And we now know, based on the representations of 4 jurors, indirectly a 5th, no contradiction from any of the 7 or 8 other jurors, that there is a trustworthy, corroborated, and we contest uncontradicted showing that the prior jury reached a unanimous decision to acquit Ms. Reed of 2 of the 3 charges in a multiple count indictment that she was tried on in Norfolk County. I want to first.
What is the factual basis for your assertion that the jurors who contacted the DA's office are different people from the ones who contacted yours?
I don't have a basis to.
Okay, so when you say 7 or 8, that's speculative?
The numbers are that 4 of the jurors directly contacted the defense. A 5th, there was indirect proof
Sure.
that a 5th juror contacted the defense. A juror who could have been one of the 5 and could have been one of the 7.
Okay, so you're not representing that it's more than 5?
That's correct.
Okay.
See the clock in front of him? It's counting down 13 minutes. He's got 13 minutes and 18 seconds left. So I'm assuming he got 15 minutes to start.
What I am contesting is that there was no manifest necessity for the mistrial, which is issue 1. There was no consent, issue 2, and that this court's jurisprudence strongly suggests that the defendant has met her burden of production and is therefore entitled to a post-trial jury voir dire by the trial court, at which we contend the probability, if not the certainty, that that voir dire would result in proof that there was a final and binding.
Mr. Weinberg, you jump all the way to acquittal, correct?
Yes.
Under Rule 27, the verdict has to be unanimous.
Yes.
It has to be a general verdict returned by the jury to the judge in open court. And then the second element, the jury has to file a verdict slip with the clerk upon the return of the verdict, which is a written recital of that same verdict. Here, none of those elements were met.
Correct.
In the face of the juvenile case, in the face of Taylor, how is this an acquittal?
It's less a matter of labels. I could call it, Judge, a unanimous
Well,
decision.
you cite Taylor, which is the case in Quincy where the judge, basically there was a procedural defect in the complaint, and the judge, for lack of a better term, pulled the plug on the case, and we had to decide what was that. Was that procedural error, or was it a judgment on the merits? And we decided whatever the judge said, it was a procedural error.
Yes.
That case is an opposite to what this situation. So how do we say it was an acquittal without a verdict in open court and no verdict slip?
I think you say that there was.
Don't worry about that. This panel is never going to just acquit her. He's saying, why are you jumping right to acquittal? They asked for 2 things: either acquit her of those 2 charges or let us inquire further of the jury. He's saying, why do you think we should just acquit her? Don't worry about this. We never expected them to win this argument.
It's a unanimous decision made by the jury that is subject to the proof that would come from a post-jury voir dire. I don't contest that this court should just impose an acquittal and substitute a verdict because of the declaration.
Well, that's a double jeopardy claim, right?
Yes, it's at the core of double jeopardy that if we can prove, and I suggest we've more than met the burden of production of proof, more than in many cases where this court is remanded for jury voir dires, that if that jury voir dire established, which is what we contend it would if ordered, that this was a final and unanimous decision made by the jurors, but they didn't announce it.
The post-verdict inquiry is usually or exclusively limited to extraneous information in front of the jury, charges of racism in the jury room, etc. Here, do you want us to carve out a new exception to that rule?
I think
Yes.
it's an extension of prior precedents. Fiddler talks about not establishing inflexible rules that would expense justice at the price of certitude. In Fiddler, there was evidence from the jurors that there was evidence received by a jury that didn't come from trial evidence. So that was.
Doesn't Fiddler caution to not inquire into the, to not to intrude into the sanctity of the deliberative process as well?
It does.
Absent this extraneous influence. But the influence in this case is not extraneous. It has to do with the very deliberations that occurred, correct?
I would argue that it has to do with the results of those deliberations,
Right.
and that a carefully set of questions preceded by an instruction to a voir dire jury. We don't want you to disclose why you reached a result or the content of your processes.
Yep.
We want to ask you about a result. Did you vote on count one? How did you vote?
You seek to impeach the written communication by the foreperson, correct?
I'm sorry, Judge.
You seek to impeach the written communication of the foreperson, correct?
I would say that the
Clarify.
recent jury declarations demonstrated that there was facial ambiguity in those communications. Yes, they related to a lack of unanimity, to a deadlock about charges. The count two by itself, read vertically, had multiple charges. Horizontally, there were three separate counts. There was ambiguity. The trial court didn't realize it. The trial court erred in not allowing what Taylor and Stewart mandate as imperatives before there was a ruling of manifest necessity. No opportunity for a defense lawyer to make arguments about options to the declaration of mistrial, and I contest that there were at least three viable options that Stewart, Taylor, and all the cases of this court mandate be, quote, carefully considered.
You've got an exhausted jury writing this very eloquent message saying, we haven't been, we've done our best. We haven't been able to reach a verdict on any of the charges. There's no inkling in that they've.
No, they did not say on any of the charges. They did not say that. You guys, Massachusetts, you need to carve out a new exception, just like your brother judge just said. Carve out an exception. This is a case of first impression in Massachusetts. It's never happened before. You need to carve out an exception because the judge didn't ask if they were hung on all charges.
Reached verdicts on charges, or that this only relates to the second charge, right?
Facially, there was the words charges and the words in deadlock.
Of what's going to happen with this motion for new trial, right? Everyone thinks the jury's done its best. It's exhausted. It's tried every option, and everyone's resigned to trying the case again. I understand something happens later, but at least at that point, is it really a mistrial? I mean, is there an error to declare a mistrial?
I would respectfully disagree that everybody concurred that there was only one reading of this note when the defense had no opportunity, despite the clear jurisprudence mandating that they be given an opportunity to be heard.
Did the defense have an opportunity when there was a discussion about scheduling after the jury was sent into the room?
It was too late.
Once the judge discharged the jury, once the judge thanked them and said that the case is over, the failure to make an objection was futile. It was unnecessary.
What about the case of Commonwealth versus Enid Brown, where the jury was sent? The jury goofed, essentially. There was a miscommunication between the clerk and you know the case. The jury was discharged, sent into the jury room, and then we said it wasn't error to bring the jury back after discharge to clarify the verdict.
And had the jurors that signed that or that made these representations starting the very day after the announcement of the mistrial, if they had told the judge.
But I guess the point I'm asking Mr. Weinberg is there was a time period, and I get your point that it was hasty to not have consulted with the attorneys before bringing the jury in. But be that as it may, after the discharge of the jury, I'll talk to you later, as most judges do. The lawyers then talk about a scheduling conference and timing of it. Wasn't there an opportunity at that point for the attorney to object and say, this is what should happen, these are my thoughts?
There was an opportunity, but not a responsibility. The law in this case, starting 39 years ago with Stewart, places the heavy burden on the Commonwealth which wants to re-prosecute a citizen in the face of the decision of the first jury, to recommend alternatives to the judge. And the trial judge found consent, in part based on the failure to make an objection.
And I think we cut you off when you said there
More
were
than
three
once.
things that could have happened. Could you please tell us what those are?
Yeah, one is the trial judge receiving this note, and remember, didn't read the note to the defense, didn't give them an opportunity to be heard, said, bring the jury in. The jury comes in seconds later, 30 seconds if the court were to look at the video, which has been relied on by my brother as well as the trial court. The judge could have said, I've received this note. Does it relate to all or just some of the charges? That's not a coercive question, and there's no capacity to coerce, the jury into redeliberating. It would illuminate the implied ambiguity, which is illuminated by the jury declarations, that there were two ways to interpret the note.
Don't you think we're supposed to assess the judge's decision-making or thinking in the context in which it occurred, which includes two previous notes reporting impasse? You argued very forcefully below that the jury had reached an impasse and for the Tui Rodriguez charge to be given. I'm assuming you made that argument in good faith.
The argument was made in good faith.
Yes, and there was no information intervening the second time you made that argument, no additional information about the jury's thought processes between that second note and the third note.
I would respectfully suggest that when a defense lawyer asks...
I'm not asking for an argument here. I was going to ask you for a reference to the record to indicate anything that happened in between the third note, the second note, and the third note.
Yes.
That would indicate any less of an impasse between the first, second, and third notes.
Yes, what happened is that...
I'm just looking for a record site.
The record is the jury went out and deliberated for several hours.
She wants to know the page.
Subject to TUI instruction, which is designed to encourage a jury to reach a verdict when they've declared an impasse.
Right, so I understand your answer to be there's nothing in the record to indicate that they were at any less of an impasse than they were when they sent the second note.
No, and I would contend that all three notes are ambiguous. The defense...
That was not the argument you made below.
The argument made by trial counsel was to argue not for a mistrial. They never asked for a mistrial.
I understand, but there was no argument that these notes were ambiguous down below, correct?
Down below at the trial court, yes, the argument made on the motion to dismiss was that there was ambiguity.
Not at the motion to dismiss, at the time.
They had no opportunity at the time.
First note, was there an argument made concerning ambiguity in response to the first note reporting impasse?
No, there was a request for TUI.
Was there any ambiguity argument made in response to the second note?
There was a request for TUI. But the only time that I suggest matters is the third note where they had no opportunity to make that argument.
Why would that be? Why would we just focus not on the totality of the three notes, but just the last note? Why is that, in your opinion, or actually citing any legal authority, why would that be the critical moment?
Because
Okay, if anybody in the courtroom is listening, tell him he's got to argue that the jury instructions were ambiguous, that she told them, do not come back to me until you've reached a unanimous decision on all of the charges. Judicial error.
Before that, there's at least an impasse on one count, and there is no obligation on a trial court in terms of timing when to seek a partial verdict. When Judge Discasiano asked me for what the three alternatives are, one of the alternatives was simply to ask the jury what it meant. The second was to apply Rule 27B, which says before a mistrial, a court may request of a jury whether or not they've reached any decision on any of the other counts. The reporter's notes...
At the moment of the declaration of the mistrial, what suggested in the notes, the three notes, that there was any agreement as to any of the three charges?
Facially, they said they were at an impasse, and the court has an obligation to carefully consider all alternatives under Taylor and Stewart. There's no evidence on this record that the trial court made that consideration.
Well, after the first note, she asked counsel and the prosecutor, what do you think? And I thought defense counsel argued they've exhausted their review of the evidence, and so give the Tui Rodriguez, and the prosecutor said, not yet. And she said, yes, no, not yet. And then there was the second note where again, they report that they're in an impasse quite eloquently. And again, at that point, the prosecutor says, don't give the Tui Rodriguez, and the defense counsel says, yes, go ahead and give Tui Rodriguez. And she considers that alternative and gives the Tui Rodriguez instruction.
Yes.
Now we have the third note. We've really tried on all the charges. Some of us agreed that beyond a reasonable doubt, that the elements of each of the charges have been established. Some of us do not. And at that point, she's considered the alternatives. Let them continue to deliberate, give the Tui Rodriguez, and the third time, it sounds like that everybody's in an impasse. That's all the information she has.
And that's part of the perils of not providing counsel with an opportunity to be heard, which is what was required. Because we don't know that the jury notes 1 and 2 didn't also relate to 1 rather than 3 counts. What the defense wanted was a verdict. If you want a mistrial, you ask for
So
one.
your
They
rule
asked
would
for a
be
Tui
that anytime there's more than 1 charge.
Yes.
The
Yes.
judge must
Yes.
ask when the jury reports back that they're in an impasse. The judge must then ask, well, are you at an impasse as to count 1? Are you at an impasse as to count 2? As to count 3?
Yes.
That's the rule.
When there's a multiple count indictment, that's the rule as described by the reporter to 27B, which is a trial court must make that inquiry before ordering a mistrial.
I thought it was a may, which is the one where.
The may was in the rule. The reporter's note says must. I would argue the may relates to timing. In other words, there's no obligation of a judge at any particular time to ask the jury whether there's a partial verdict. But if you're going to issue a mistrial order, that's where the must comes in. And
In the ordinary case, the foreperson will say, we've got a verdict on counts 1 and 7, and we seal them. And then we.
She told them not to do that.
Try the remaining counts, correct? When you say it wouldn't be coercive to ask, am I right to assume that you're relying on Rule 27B?
27B and the distinction in the Roth case, which is there is a risk of coercion if you're dealing with a single count with multiples, but 27B preempts that in terms of the importance of a mistrial order.
And your argument to Justice Wendlandt, and I guess to me as well in the court, is that that is not discretionary.
My argument is that given the core values of double jeopardy, that unless the defense consents to the mistrial order, the court has to comply with the guidance, the principles, the mandates of Stewart and Taylor. And here they complied with neither one of them.
And that's absent any other evidence as far as the deliberations go and the notes that there's an agreement, or at least partial agreement on a particular verdict, correct?
Yes, those notes were subject to one of 2 interpretations, and given the obligation of a trial court to consider all alternatives, including the alternative post-Tui of seeing whether the jury wanted to deliberate on any one of the 3 counts, which is part of the statute. I think it's 268-34C. That's a third alternative. Here, the problem is the record doesn't reflect the trial judge's consideration.
As a matter of
these
fact, were there
alternatives.
3 separate verdict forms?
There was
Yes.
actually more than 3 verdict forms because the verdicts on count 2 had multiple, they had 3
So
different
count
options.
1 and 3, were there separate verdict forms for those?
Yes.
I believe there were
separate pages.
forms, but there
Yeah.
was, guilty, not guilty, count 1, count 3, and count 2. There was supplemental instructions and an amended verdict form to make sure the jury had options that were consistent with the law of the SJC as to how you deal with lesser includeds.
Can I ask, sorry, so I'd like to ask, how are you, the judge says she can't ask the questions that you're saying she could without interjecting herself into deliberation. So let me read what she says. While the defendant contends that the conflict is reflective of the fact that the instruction given to the jury by the court were confusing, determining whether this is true would necessarily require inquiring into the back and forth among the jurors during deliberations.
It's turning
Can you tell us
around.
how?
Yes.
Why? How would she do this? She doesn't envision a way that she could ask the questions you're talking about without requiring them to explain whether they took votes, how they took votes, what the votes were.
Did you
Just
acquit
tell me
on
what
count
your
one? Yes or
thought
no?
process is on
My
that.
thought process, one is that this court has the option of essentially informing the court what questions can be asked. And two, if we're going to delegate.
Require follow-up questions. And unlike extraneous
wouldn't.
influences where you can say, okay, we only want to inquire about whether there was a racist statement made or something to that effect. This is different. We're going to have to require what their votes were, how solid they were.
No, it doesn't matter how solid they were. Did you agree to acquit on count one? Yes or no? Did you agree to acquit on count three? Yes or no? On the up and up, don't be terrified. It's turning around right now. They're not going to ask them why they voted that way. Just did you vote to acquit on count one? Yes or no? It doesn't go to the province of the jury's deliberations. It goes to the verdict.
Isn't that going to get into deliberations?
No.
Inevitably.
I think you could ask about the results of deliberations. I would design it by saying an instruction to the jury to not disclose the content or your processes of deliberation. But I want to ask you the following questions. One, did you take a vote on count one? What was your vote? Was the vote unanimous amongst other jurors? Was the vote final? Was it ever reconsidered or rediscussed?
That question, was it final? Isn't that gonna, the jury can change its mind, right?
Could, but there's no.
But isn't that gonna result in asking that type of question? When you say final, if you don't get your way on two, is it final?
Was it ever reconsidered? You know, my contention, based on these juror declarations, based on the voicemail, based on the fact that in this highly publicized case, no other juror, they served for months, says to anybody, to the court, to the clerk, to the court officers, to the prosecutor, wait, I didn't agree.
They also don't write in saying we agree with the other five or anything to that effect. They're silent. As their deliberations are supposed to be silent, right?
But it's an almost unprecedented meeting of the burden of production. If this was a Sixth Amendment issue, the jurisprudence of the court would compel a post-jury inquiry. The Fifth Amendment values are just as important. Questions can be designed, whether it's final or was it ever reconsidered, that would demonstrate what we contend. These were final votes. This was the end of counts 1 and 3. It's exactly what Juror D says. We went to the bus and says no one's ever going to know that we voted to acquit.
Isn't that part of the problem? And isn't that what Bluford counsels against? Because you keep saying that whatever was done on counts 1 and 3 were fixed. And despite the fact that there was potentially still some uncertainty about where.
Well, something might have been fixed, but not in the way he's talking about. Don't worry. They're going to question the other side just as fiercely.
The folks were on count 2, that could never change in the continuing deliberation about count 2. And isn't that what Justice Roberts was talking about? The deliberations weren't finished. They weren't finalized. And you keep using that term. But there's still opportunity for folks to change their positions in the context of the continuing deliberations on count 2 and its lesser included. So what's your best authority to say that it was fixed for all time and for all deliberations, and there was no opportunity, particularly when we don't know that no one, to Justice Kafker's point, has called and said, hey, me too, we believe the same thing, for the court to say that this is what it meant for all time.
So,
At the point of discharge, had you voted to acquit on count 1? It's really not that difficult. It's really not that deep of a question, in my opinion.
the answer to the question, and I understand the question, In the Bluford case, we had the return under Arkansas law, which prohibited partial verdicts. The jury said that they'd reached a decision, they were sent out again, and then they said they had changed that decision and were at an impasse. In this case, a post-jury voir dire can ask about whether or not you took a vote. Was it unanimous? That doesn't intrude on the values of 606B. Was the vote ever reconsidered? Was it final?
But that's my point.
Don't ask if it was
If
final.
you stop right there and say that's the end of the inquiry, that's really not true, because there's still deliberations that are left on count 2 that might inform a juror's change of position on count 1 and 3.
And that could be the subject of a jury inquiry as to whether or not the unanimous vote that acquitted Miss Reed of murder and leaving the scene was ever reconsidered. You can ask for a result without probing into a mental process, into the content of deliberation. The values at stake here are too important. Yes, in the McCallop case, we allow a court to ask about mental processes. Was there communications of bias? In Fiddler, they talked about the communication of evidence that wasn't received through the gatekeeper function of the trial court. This is important. Miss Reed was acquitted by those jurors, and we should have the opportunity, or not acquitted, we contend, a unanimous vote. We should have the opportunity to have Judge Cannoni conduct a voir dire. It's done when one juror says there was a statement of bias, when one juror says there was contact with an external source.
Right, but when it's an extraneous source, then you need not get into deliberations. But as I listen to you suggest questions that the trial judge could have asked, it seems to me those questions go directly to the jury deliberations.
And I would contend they go to the results of the deliberations. They do not require a judge to ask, why did you vote not guilty? What led you to vote not guilty?
So the question asked to juror F would be, was that vote final?
Yes.
Juror F's answer would be, well, no, it kind of depended on how I would have voted on count 2. We were not yet done.
And that would reflect two
It's
things.
a jury deliberations, right?
That would reflect that the voir dire by the judge did not lead to a result of a final unanimous verdict of not guilty. But to foreclose those inquiries when there's a real possibility 12 jurors are going to say to Judge Cannoni, if conducted, that was my vote, it was not guilty. We never reconsidered it. We considered her innocent. We didn't think she intentionally killed anyone. We should not be foreclosed from having that option.
It seems to me that what you are in effect asking via a post-trial inquiry is to discover whether the jury disregarded the jury instructions. And the reason why I say that is that the jury were instructed to return a verdict after the final vote, and I'm using that as a direct quote of the jury. So when they had a final vote, they were then to check the appropriate boxes as to each charge, then sign and date the verdict slips. And it seems to me, or at least please correct me, why isn't this post-verdict inquiry that you're suggesting actually an attempt to try to establish that the jury didn't follow the instructions? We have a long line of jurisprudence.
The instructions were, do not come back to me. Do not fill out any of the forms until you have reached a unanimous verdict on each count, on all counts. That's what they were told. He's got to argue that.
That says we presume that the jury follows the instructions.
And there is cases where, when mistakes are made by jurors, where they don't fill out the verdict slip accurately. The Capen
That's not
case.
this case, though.
No, this case, I think, is a stronger case for a voir dire because we're not impeaching a verdict. We're explaining a note. We're asking the jury to resolve an ambiguity within the note that the trial court didn't realize, in part because they didn't provide an opportunity for argument, in part because they used a procedure that's totally at odds with this court's jurisprudence in Stewart and Taylor. And before we get to the voir dire issue, we contest there was no manifest necessity. And
Before you shift back to that, what's the best case? That's federal, because we're interpreting federal law here. What's the best, closest case, and not an extraneous influence case, allowing this type of probing after? If we want to go back and read one case that's going to do what you want us to do, what's the closest case?
It's actually a Mississippi case. I think it's named Martin versus State, that the amici brief brought us to, where they read the newspaper.
It's a state court case, right?
Yes, it is.
Any federal cases? Because again, this is a federal constitutional issue.
You know, there are cases where jurors correct verdicts.
No federal case
This is,
that has the, you're asking us to direct Judge Cannoni to do this. I just would be helpful if you have a federal example that we can turn to, because we're interpreting federal law, not our own law here.
well, this court has a long history of applying federal
We don't have any
constitution.
cases except extraneous influence cases. I'm just again, your chance.
You do
Best
have,
case that we should look at for you.
you do have one example, which is the McCulloch case, which follows a Supreme Court case and allows the jurors to disclose their deliberations regarding ethnicity and racial
Again,
bias.
that's extraneous influence. It's different.
It's internal to, I think it's closer to the core of 606B.
No federal case we can turn
There's-
to, for example.
Nor has the prosecutor come up with any case to the contrary. This showing by this jury, it's not going to open the floodgates for post-voir dire.
Well,
This is-
actually, that was my question. What's the limiting principle here? It sounds like if ever a juror comes back to the defendant and says, hey, that's not really what happened, then we open it up.
This would not be a case where a juror has second thoughts, is reconsidering, didn't think she was, he or she was listened to in the jury room. These are representations by 4 jurors that were unequivocal, unconditional. They said we reached a final verdict of not guilty, and
So the jurors submitted affidavits?
The jurors.
No, they're not allowed to talk to the
wouldn't
jurors.
Submit affidavits. If we asked the judge, if you're not going to accept the lawyer's affidavits, please authorize the lawyers to go back to the jurors. But we didn't want to walk near the boundaries of 606B. The judge accepted the truth of the lawyer's affidavits as a substitute for the jurors' affidavits. But again, let us voir dire the jurors. The judge has the power to make a decision. Was there a unanimous verdict of not guilty?
But our review is an abuse of discretion. Why was it an abuse of discretion for her to deny you that ability?
Because the Stewart case says the deferential appellate review depends on whether or not there's proof of compliance with the principles set forth in Stewart, meaning did the judge carefully consider all the options? Did the judge give the defense a full opportunity? These were mandates, not discretions. They're conditioned precedent to the declaration of manifest necessity. It simply wasn't followed in this case. It wasn't followed the basic rules of Floyd P., which is when a jury gives a note, you share it with counsel, you listen to counsel, you get their views. We don't know whether counsel would have advised the judge about 27B, or would have asked the judge to ask the jury whether to.
Counsel, can I go backwards on that?
Sure.
Because part of I don't know what part of this goes into the calculus, but you have 2 extremely experienced trial lawyers. No one in that room would ever think potentially a mistrial may be declared after Tui Rodriguez is given. There isn't any lawyer that's worth their salt that wouldn't think they might get a mistrial on this. So you know where the puck may be going when it comes to giving to Tui Rodriguez. And
Hockey
you say that
reference.
there was no manifest necessity for this and no opportunity to be heard. How do we factor in that you've got to know that that's going to be on the table, is that a mistrial? And what obligation is there on counsel to say, hey, before you declare a mistrial, let's talk about alternatives to that?
So let me address that. Judge comes in, deviates from her prior practice where she gave counsel a full opportunity, announces to the defense lawyer there's an impasse, bring the jury in. If your honors would accept the audio video that, again, the district attorney has relied on, it's about 30 seconds till the jury comes in, but you hear a door open. Defense counsel don't know what's in the note. It hasn't been read to them. They don't know what the judge's intentions are. They don't know whether they'll be invited to come to the bench to discuss it. They have to be surprised they weren't given an opportunity. They hear a door open. The jury could come in 5 seconds, much less 30, and I stand before you with 52 years of trial experience to say no competent defense lawyer would risk the wrath of a judge or jury by interrupting that process, by making objections. So
The judge said they're at an impasse, bring in the jury.
bring in the jury, and you can actually hear a door open.
Okay,
So
and you have 30 seconds to object.
but you don't know that it's not 5 seconds. You don't know the door's not open. You don't know the
You
jury.
can
can't
say, Your
hear.
Honor, may I see you at sidebar?
Come on.
In this case, that's happened repeatedly? No?
Here, the defense lawyers did not know what the judge's intentions were. They didn't know what was in
But
the
they
note.
did know that the jury had reported to her that they were at an impasse.
They were an impasse, bring the jury in. Yes, that was possible, but to
What was
extinguish,
possible?
to ask to go to the bench, but
Yes.
this court.
And did that happen?
No, but neither did it happen that the prosecutor, who this court says has a heavy burden because they're the sovereign, they want to re-prosecute somebody after a mistrial, to subject them to the perils of a second prosecution. The trial court did not impose a burden on the prosecutor. They have more of an obligation in double jeopardy law to raise options to a mistrial. And I don't think it's fair to conjecture consent or to penalize a defense lawyer
For
when they
silence.
have been relying on a procedure that's lawful, where defense lawyers have a full opportunity to be heard. They don't know what's in the note.
She doesn't need the consent of the defense to declare a mistrial. She needs to determine that there was manifest necessity for a mistrial,
After a
correct?
careful consideration of all alternatives and after giving the
That may
defense an
explain why
opportunity.
perhaps the judge did not inquire, was because given, I don't mean to replow the same territory, but this was the third note.
It was the third note, but it was a note that demonstrated, because of the deliberations between the second and third, that the defense didn't want a mistrial. They wanted the verdict.
Mr. Weinberg, are you aware of any cases, or can you let me know if there are any cases where the judge gives TUI,
Yep.
and then the jury comes back and says, we're deadlocked, as articulate as this jury was or not, and then the judge does something different other than just declare a mistrial?
Well, the statute itself says the judge has no right to obligate the jury to redeliberate, but every right to ask the jury whether they would consent to continue deliberations. And here I
But
contest.
here, the jury said to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
But in the face of that, do you think give it the old college try is okay?
I think that the judge had alternatives that the record does not reflect were carefully considered, including, is your deadlock on all three counts? Is there any, would you consent to deliberate on any count that you've not reached an irrevocable deadlock? Questions like that are not coercive. Questions like that would have actually given the illumination post July 1, and I'm not arguing that that provides proof as to what the process was on July 1.
In the statutes, again, is
Yeah.
a may, correct?
The statute says, 27B says a court may make that request, but the Stewart and Taylor rule require careful consideration. That at minimum was an option not
The careful-
considered.
The careful consideration is basically all that has gone on as far as the length of deliberations, a number of notes, et cetera, and what the notes say. That's part of the calculus, correct?
Yes, the judge made her own judgment, and I'm not saying the judgment was irrational. I'm saying that she would have been aided by counsel. The law required she give counsel an opportunity to be heard.
Mhm.
There's no evidence in the record she considered any option except to declare a mistrial. That contradicts the clear jurisprudence of this court, and I contend it contradicts the core protections that double jeopardy give to a defendant against being re-prosecuted, which the Supreme Court has said carries with it the risk that an innocent person can be convicted, the ordeal of a second prosecution. This court has given procedural guidance, conditions precedent. This is what the words are must. 27B may be discretionary, although we argue the reporter's note in combination with Taylor required that inquiry about partial verdicts. This court has told the judges ordering a mistrial is irrevocable. And you need to go through certain procedural conditions precedent, and the judge did not. And I respectfully submit that extinguishes the principal basis to say there was manifest necessity in this case. There was never a knowing and intelligent consent. The defendant never asked for a mistrial. And at minimum, secondly, we strongly ask this court to extend the Sixth Amendment jurisprudence where you allow jury voir dires into the Fifth Amendment. The Fifth Amendment is as important as the Sixth Amendment, and a jury voir dire conducted by an experienced judge can determine whether or not there was a unanimous and final verdict of not guilty on 2 counts, one of which carries with it a life imprisonment. I thank you very much for the privilege of appearing before you today.
Thank you.
Okay, so they gave him
Okay, Attorney Schillinger.
the first 15 minutes, and then they extended his time by another 24 minutes and 43 seconds. So just everybody take a deep breath. This is exactly what happens in appellate courts and Supreme Courts. They're going to hammer you on the things they don't agree with you on. And now they're going to hammer Schillinger as well. So let's watch. If you're ahead on another stream or somewhere else, we are a little bit behind, so please no spoilers in the chat. Thank you so much for watching. There's over 5,000 of you in here. I would love it if you would smash the like button, or I will turn off the air conditioning. God save the Commonwealth. On to Mr. Schillinger, a Harvard-educated appellate lawyer for the Norfolk County District Attorney's Office. We won't get an answer today, no.
Thank you. Okay, Attorney Schillinger.
Good morning, Your Honors. May it please the court, Caleb Schillinger for the Commonwealth. With me at council table is my colleague, ADA Laura McLaughlin. I'd like to start with the mistrial issue and emphasize a point that has been touched on through the questions to my brother, but that I think is important for the court to consider, and that is the trial strategy.
My brother is back. For those of you who are not familiar, they call attorneys sometimes in Massachusetts, instead of saying my opposing counsel, they call them my brother, my sister.
Here, as a general matter, absent some sort of definite indication from the jury that they're prepared to find a defendant not guilty on a charge, effective defense counsel is not going to ask the judge to start probing, or not going to want the judge sua sponte to do that, because doing so runs the risk of extracting a guilty verdict and convicting your client instead of obtaining a mistrial across the board.
But what do we do with the fact that after the third note, the jury is called in? There's not, unlike the first and second note where she says, okay, counsel, let me know what you think. Here, we don't have that opportunity.
The judge did inform counsel that the jury was at an impasse, and I would argue at this point, it is clear that a mistrial is inevitable or unavoidable. The jury has twice already returned deadlocked. The defendant has argued strenuously that they are deadlocked. They've been given to E. Rodriguez, and now the judge informs counsel they're at an impasse. At that point, counsel couldn't credibly believe that the result here was going to be anything other than a mistrial. And again, in addition, just to circle back, All the more so, Your Honor, because of what was their defense in this case. The defendant's defense was that she didn't cause the victim's death, but allegedly had been framed. If the jury were to come back with a guilty verdict on any of the charges, or either of the lesser included offenses, they would have necessarily had to find that the victim did cause, or excuse me, the defendant did cause the victim's death. And it would have been a rejection of that defense and the defendant's public narrative. The defendant here did not want the judge to do more into
Rather
a
than speculate what the defense wanted, let me ask you about what happened. Did the judge have either the discretion or the obligation to ask the jury after the last note about continued deliberations or a verdict on any lesser included offense?
No obligation, Your Honor. It perhaps is a matter of
Did the judge have the discretion to do so?
Rule 27B is discretionary. The language of the rule itself consistently refers to what a judge or a jury may do. I know the defendant argues.
So it's not inherently coercive.
So
If the judge has the discretion, it can't be coercive, correct?
Well, no, it's a matter of discretion, and then consider the factors that inform the exercise of that discretion. And that's what the judge did consider here. On the one hand, the judge had no doubt, based on the jury's notes, that they had not reached agreement on any of the charges. Further, the jury's third note had triggered 234A 68C, so they couldn't be compelled to continue deliberating. They made it abundantly clear they did not consent.
Unless they want to.
Unless they wanted to, exactly. But indicated that if they were forced to continue deliberating, any verdict they returned wouldn't be a just verdict. It'd be the product of compromising their deeply held beliefs and moral convictions. You have that on the one hand informing the exercise of discretion. On the other hand, you have strong countervailing reasons that argued against making further inquiry here, which is the potential for coercion. You have a jury that has sat through a grueling 10-week trial, nearly 100 witnesses, hundreds of exhibits. Now 4 or 5 days of deliberations, they've returned 3 times indicating that they are deadlocked, they are at an impasse, and they do not want to continue to deliberate.
But counsel, I'm sorry to interrupt you on that because I don't want to miss this point. But wouldn't that go to the calculus of manifest necessity? Because all of those things seem to be the reasons why you would tell counsel about the last note and say, what do you think? Because you have gone through this 10-week trial. You have gone through the impanelment process. You've spent a lot of time, energy, and money, anxiety, and angst in this trial. Why, when we talk about what potentially we could do short of saying, mistrial, let's start again?
Certainly, Your Honor. And I think, in hindsight, seeing, the quote unquote remarkable turnaround of the defendant's position, would it have been better? Would it have been preferable for the judge to take that extra step? Perhaps, and another judge might have done that. But here, given the progression up to the...
And perhaps another judge might have done that. This lawyer is excellent, by the way. He is excellent. No shade to Caleb Schillinger whatsoever. He is very skilled. He's very calm under pressure. He's very paused. But what he just said is not going to play well. I'm going to play it back because that's how important it is. I want you to hear it again. Perhaps another judge might have done that, but not this judge. And what this justice is saying to him is, but doesn't that go to manifest necessity? Doesn't she have the duty to inquire if there are other alternatives before just sua sponte declaring a mistrial?
Position, would it have been better? Would it have been preferable for the judge to take that extra step? Perhaps, and another judge might have done that. But here, given the progression up to the third note, and in particular, given the defendant's response to each of those 2 prior notes, I think the judge could reasonably conclude the jury is at an impasse. There is a manifest necessity for a mistrial. There is nothing more to be done here. And in fact, in her order denying the defendant's motion to dismiss, the judge did say a mistrial was inevitable.
You can't find consent, right? If you don't ask.
She also said there were no shrinking violets. You recall?
You can't find consent, right? If you don't ask, the consent is out the window, isn't it?
I don't agree, Your Honor.
Really?
Find consent through the lack of an objection here.
No, silence is not acceptance.
Burden of proof is on the Commonwealth. There's no opportunity whatsoever for the defense counsel to raise anything. I get you may have manifest necessity, but I don't see how you can get consent when they haven't been consulted in any way.
They were consulted in response to the first two notes. And what was the defendant's response to those notes? It was to argue in favor of due and thorough deliberation and accelerate the process at every step toward a mistrial.
But pushing towards a verdict is different from, that's different. I mean, they want a verdict. Because they want Tui Rodriguez doesn't mean they've consented to a mistrial.
Even so, Your Honor, they had opportunities to object. They could have objected while waiting for the jury to enter the room. 30 seconds is ample time to at least ask, may we be heard at sidebar, Your Honor, after being informed that the jury's at an impasse. They could have brought the issue up again during the scheduling conference after the jury was excused to the jury room. And even after that, they still could have brought it up. And we cited in our brief Fuentes as an example of where a defendant lodged an objection after the fact, after the jury had been excused to the jury room. And at that point, the judge did still consider counsel's arguments. And I think given the defendant's response to the prior notes, it being clear what the defendant was advocating for here, and at the point of the third note, it being unavoidable based on manifest necessity to declare a mistrial, the absence of an objection here, or even asking to be heard, Your Honor, indicates consent.
You might have, I know it probably is in your brief, but what's your best case for that?
This case is closer to Pellegrin, Your Honor, and very different than Horrigan.
Mhm.
So as between the two, certainly where there is something abrupt that happens that is inconsistent with the way defendant has conducted him or herself, the approach that they have taken during the trial, it would be difficult to find consent. Horrigan is an example of that. Judge comes in, abruptly announces, trial judge is unable to preside, I'm declaring a mistrial. There was no indication there that, the defendant was in agreement with that. But here, again, where you have the defendant advocating for the result of a mistrial, the ultimate conclusion of it, when it is then ultimately declared to not.
How do you know the defendant is advocating for a mistrial?
That's
as
right.
opposed to
A verdict.
Because, Your Honor, not just what they argue, but what they argue.
Because Tui, there's two results of Tui. It's either a verdict or it's a mistrial, and it pushes the jury to its extreme. So when you say
We just saw that if you guys are watching the Melody Farris case. They were given the Allen charge, which is called Tui Rodriguez in Massachusetts, which is like a last ditch effort. Come on, guys, you can do this. You're better than any jury. Come on, give it one more college try. And they came back with a verdict. They found her guilty. And that's often what happens with a Tui Rodriguez charge or an Allen charge.
that they're advocating for a mistrial, they could have been just as well advocating the jury for that final push. As the Tui Rodriguez instruction says, you need to check yourself. One side has the burden of proof. It's very favorable in some instances to a defendant. So how can you stand up here and say that they were pushing for a mistrial?
Perhaps as to just Tui Rodriguez, although as a practical matter, as Justice George has pointed out, experienced defense counsel understand that there's not going to be a mistrial before that instruction has been given, or very likely. But set that aside, Your Honor.
Well, I think experienced counsel know that you're most likely not going to get further deliberations, but counsel also know that it could very well, it's a flip of a coin. It could be a verdict or it could be a mistrial.
Right. On top of that, Your Honor, I would point to, in response to the first note, the Commonwealth argued against a finding of due and thorough deliberation. Hasn't been enough time, let the jury continue to deliberate. Already at that point, the defendant was prepared to argue there's been due and thorough deliberation. I think the exact quote is, we believe there's been sufficient time. Disagreed with the Commonwealth's reading of the note from the juror that there might still be the possibility of reaching a unanimous verdict, arguing they'd already exhausted all manner of compromise, all manner of persuasion. So, and then again, in response to the second note, again argued there's been due and thorough deliberation. Those arguments are pushing to the point where 234A 68C is triggered, and the jury cannot continue to deliberate, and a mistrial will have to be declared unless they consent to further deliberation.
I think it's safe to say that they were pushing for a TUI instruction, correct?
Yes, they asked for that as well in response to both notes, Your Honor.
Do you need consent in order to win?
No, Your Honor, there was manifest necessity for the declaration of a mistrial here.
And so absent the consent, we can just, you think the manifest necessity existed?
Yes, I don't think that the judge abused her discretion in declaring a mistrial for manifest necessity based on the jury deadlock in this case for the reasons that we have discussed and were discussed.
Well, but counsel, we also have, and not necessarily in this context, but we have in cases where there are evidentiary issues, where we have found that the trial judge abused their discretion when they didn't utilize something that they could have. And so in record here, where there, again, it's not necessarily prescriptive, but there's 27B that says may, there's other things that could have been done short of declaring a mistrial. Is there could be an abuse of discretion because there's nothing to suggest that she went through the progression of what she could have done short of declaring a mistrial, which directly goes to not giving defense counsel an opportunity to say, hey, we've got all our heads in the courtroom. Let's all collectively think about this. And perhaps we can all come to some other vertical other than declaring mistrial.
Right. Alternative theories. Let's brainstorm. She didn't give them the opportunity. She didn't even read the attorneys the note before calling in the jury like she did the 2 prior times. So as you see, this panel of judges plays devil's advocate with both sides. They're giving the Commonwealth attorney just as much hassle, just as much adverse questioning as they did to Marty Weinberg.
Yeah, and I think it's clear from the judge's order that she was cognizant of at the time of these countervailing considerations, looking to the jury's notes, the lack of any indication of agreement on the charges, balanced against the risk of coercion, the defendant's trial strategy, and the fact that the defendant had not been advocating for the judge to do something more. I think it's clear that the judge was aware of these considerations.
Okay, babe. The burden's on the Commonwealth, not on the defendant. It is your burden. It is your burden in a criminal trial. It is always your burden in a criminal trial. You cannot shift the burden to the defendant just because it sounds better for you. Okay, I'm going to interrupt. This is the way I do it. If you don't like it, you can go somewhere else. Thank you. For real. Like, just stop with the complaints. I'm not going to go back and watch the whole entire thing again with you and stop and comment. This is what we do here. I'm taking that back so you can hear it again.
I think it's clear that the judge was aware of these considerations and balanced them in a way that was not an abuse of discretion. Might a different judge have reached a different outcome here? Perhaps. But the judge's determination here, which is owed some deference, if not an abuse of discretion, was not outside the range of reasonable outcomes, given the jury's notes and these other considerations, Your Honor.
You don't think it would have been coercive to say, come on, jury. I know you say that you're exhausted, that any further deliberations would force us to compromise these deeply held beliefs. But did you reach a verdict on count 1?
I do think that would be extremely coercive, Your Honor.
Coercive?
Yes. And I would point the court to footnote 5 in Ray versus Commonwealth, where this court said or noted, there may be a prevailing practice among federal courts about inquiring individually of jurors as to whether they're truly deadlocked or perhaps further inquiry. But that is not the prevailing practice here in Massachusetts.
Oh, that's the argument. That's not the way we do things here in Massachusetts, judges. You know that. It's not the way we do things here in Massachusetts. We don't do that here in Massachusetts. We don't do that because we don't give a damn about double jeopardy or the First Amendment or the Fifth Amendment or any really of the amendments, because we are the Commonwealth of Massachusetts, which coincidentally is the birthplace of the Constitution. So it's kind of ironic, don't you think? Listen to that again.
It's about inquiring individually of jurors as to whether they're truly deadlocked or perhaps further inquiry. But that is not the prevailing practice here in Massachusetts, and it's not an encouraged practice. It's particularly because of the risk of coercion.
We don't encourage the truth here.
There's no discussion of Rule 27 at any point during the deliberations or sort of preparing for the deliberations, right? When we read through this whole record, we're not going to find any indication it was on anyone's mind, right?
Correct.
But so I see your point on the note is so compelling that they've worked this to the end. The problem comes when we get this new information that's somewhat inconsistent with that they've I mean, the key sentence, some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails. Then we get this motion for a new trial with 4 or 5 jurors saying that's not the case, right? That's the troubling part. What should happen at that point?
Right. And also, what is the troubling part? And I hope one of the justices brings that up, is that no juror has to come forward to say, that's not true. That's not true. We did not agree to acquit on counts 1 and 3. So if you want to use your silence as acceptance argument, Commonwealth, you can't use it as a shield and a sword. You can't say, well, the defense wanted a mistrial because they didn't say anything. So their silence was just accepting of the fact that she was just going to declare a mistrial without asking anybody. Sua sponte, without reading the note to us like she did the 2 prior times, because, you know, the defense didn't speak up. And now you can't use that argument in your favor because no juror came out and said, this is not true. We actually did not agree to acquit on counts 1 and 3. And that's imperative as well. And I hope one of the judges asks that.
Yeah, and I do want to make sure I get to this, Your Honor. The alleged agreement reflected in those statements is not an acquittal. It lacks finality of a verdict, really for 2 reasons. One is the reason that's already...
I get that point. I'm just trying to figure out what should the judge do at that point? Because they're arguing, okay, you have some follow-up obligation here. Is there no obligation whatsoever, I guess, is what?
No, and we argued below, actually, Your Honor, that it's not reliable or competent evidence because it goes to the substance of the jury's deliberations and is being used to try and impeach the declaration of the mistrial based on the jury's notes.
The judge makes a finding that she finds them credible for the purposes of this motion, right? So she doesn't say they're unreliable, but rather accepts their reliability.
That's right.
And then concludes that nonetheless that she can't inquire here without invading deliberations. It's different from reliability. She's given up the reliability point, right? She's made a finding that I accept for these purposes that those 4 jurors or 5 jurors
Correct.
are credible,
Yep.
right? So it's not a reliability issue that you can rely on, right?
Correct, but the judge also correctly or properly ruled that it would not be appropriate to conduct some sort of post-trial inquiry at this point for a number of reasons. One, this jury, a mistrial was declared, this jury was discharged. They've now been discharged for 4 months. They have no power or authority at this point to come back and render a defense.
Oh, come to your screen, my friends, if you're not watching. Look at AJ. He's got some 5 o'clock shadow. He's got a little scruff going on. It's a whole new look for Smooth as Butter. I'm not sure how I feel about that. I love both of these men, though, and I'm not ashamed to say it. Mr. Yannetti, Mr. Jackson, brother counsel. Counsels? No, brother counsel. I don't think counsels is a proper plural. Freeze game on point.
Facto verdict.
Well, the request is to inquire of them, which we said you can do in Fiddler and McGowan et al., right?
But not to get into their
Well,
deliberations.
that's a separate matter. You said that, you know, you can't bring this jury back. You can bring them back for post-verdict inquiry.
Well, it's one.
Under the guidance of Fiddler, et cetera, right?
It's one thing, Your Honor, to bring a jury back and inquire as to extraneous influences to determine whether a verdict that was returned and affirmed may have been the product of other than a fair and impartial jury.
How about extraneous influences like Brian Albert, Colin Albert, Jennifer McCabe, and Kerry Roberts staring at you from behind the, staring right at you, right across at you. Brian Albert and Colin Albert. Is that an extraneous influence too? I mean, if we want to talk about extraneous influences, let's, pot meet kettle.
It's quite another to bring a jury back to essentially construct a verdict that was never
What Mr.
returned.
Weinberg argues is what we protected are the Sixth Amendment rights to a fair trial, but he says we should expand our law, as I understand him, to include the Fifth Amendment right and double jeopardy protections as well. What's your response to that? Why not?
I agree with the reasoning of the appeals court in Di Benedetto that it can't simply be the fact that it implicates a core constitutional right to allow for this sort of inquiry. And here, unlike
Why not? Why is the Fifth Amendment any lesser of a right than the Sixth?
It's not that it's any lesser of a right, Your Honor, but although it is different than the Sixth in that here there's, a balance of two competing public policy considerations. It's not simply the defendant's right, there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Well, doesn't the public have an interest in finding out the truth of what the jury decided?
They have an
Amen,
interest in
sis.
a just judgment.
Amen, sis. No, I can't boost the court volume. This is actually a very good volume. I'm not sure who asked me that, but no, I can't. Isn't the public interested in knowing the truth? The truth shall set you free. Thank you, sis. Let's take that back.
That's right, there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Public
Well, doesn't
interest.
the public have an interest in finding out the truth of
Mhm.
what the jury decided?
They have an interest in a just judgment that is in fact a final outcome or final verdict here. But setting aside whether expanding it might be appropriate, it cannot be done in this case without getting into the substance of the deliberations. And I think my brother revealed that under questioning. There are several issues with it. One is, again, this jury has been discharged now for more than 4 months and has been subject to extraneous influences, potentially including harassment.
We've
Or
sent
threats.
back
Harassment.
jurors,
Oh,
race.
here we go. Really, Schillinger? You couldn't leave the rubber ducks out of it, could you? You couldn't leave the rubber ducks out of it. Jury's been discharged for 4 months. Yeah, but you know what, Commonwealth? Here's the thing. You got emails from jurors, I'm going to say right away, because they reached out to defense counsel the day after the mistrial was declared. They were so angry. And Commonwealth received emails too, but they never said in their papers when they received those emails. So the fact that the jury was discharged 4 months ago, subject to, now he's saying harassment. Hold on a second. Oh, they always got to be dirty. They got to be dirty. They just can't keep a clean argument. Got to sneak it in wherever they can. Here we go. Taking it back.
My brother revealed that under questioning. There are several issues with it. One is, again, this jury has been discharged now for more than 4 months and has been subject to extraneous influences, potentially including harassment.
We've
or
sent
threats.
back jurors
Yeah.
on race. I can't remember how many years. It was like a decade later or something. Timing's not going to be a winner for you, is it? It has to be.
No, that by itself, Your Honor, is not a
Ah.
reason not to do it. I'm raising it as an additional consideration or concern here. But there are others as well, which is, it's not simply a matter of bringing a jury back and trying to ask them a yes or no question. That's not how juries reach verdicts. We ask them to engage in group decision-making, collective discussion, review of the evidence. So it's,
Our post-verdict inquiry is guided, and we always say to the jurors, and we tell the trial judges, you have to instruct the jurors, do not tell me about the contents of your deliberations, answer this specific limited question. And the limited question posed by the defense, and I think in the ACLU brief, is did you reach a verdict essentially on counts 1 and 3, or was it an acquittal? Right?
I don't know that was the specific question they proposed, but I understand. I take Your Honor's point.
I mean, however
Yeah.
they phrase
gotta know the
it's
papers.
a limited yes/no question.
Yeah.
Yes, and my point is that's an artificial inquiry. Or take, for example,
We asked,
Did you-
have you reached a verdict? That in and of itself is a standard question,
See?
right? That can't be crossing the line, right?
See?
Or is it?
Well, before he even answers this, let's talk about bringing the jury back 10 years later. Do you remember those of you who are from Massachusetts, and this is a Massachusetts case, and I believe it was in the murder of Krista Worthington. Do you remember? And the defendant's name escapes me at this moment, but he was convicted of the murder of Krista Worthington in Cape Cod, or on Cape Cod. I don't know how you guys say it there, but they brought the jury back, and that may have been the case where it was 10 years later to find out if there was any racial bias going on in the right. Yes, thank you. In the deliberation room that may have led to the conviction of this Black man who was convicted of murdering her. He was like the garbage man in her town or something. Yep. So please, don't tell us that 4 months is too long of a time to call the jury back when you know damn well about the case we're talking about. See what he has to say about yes or no questions.
No, but again, I want to
Conceding.
reemphasize the point that was raised earlier, which is imagine a juror had tentatively agreed to find not guilty on a particular charge. But that was subject to further deliberation or consideration. Maybe the juror wanted to see what happened with the other charges. You now bring the jurors back and you simply ask them, I don't want to hear anything else. I just want a yes or no. It doesn't give that juror any opportunity to explain that their
We don't
agreement
need
was
to
tentative
explain.
at that point. And so it's an artificial exercise to say,
Is that what Bluford, is that Justice George asked your brother counsel about Bluford? Is Bluford the answer for you, that that's what Chief Justice Roberts was saying in Bluford, that it's always tentative? Or is it, it's only in lesser included that works? Because I asked Mr. Weinberg, is there a federal case right on point that we can look to? You at least have Bluford. Is Bluford controlling? And it's the Supreme Court.
I would argue that it is, and I actually take it one step farther, which is not only is there the concern that was raised in Bluford that the perceived agreement or unanimity here may have been the product of a very early discussion subject to further deliberation, but jurors are free to change their mind and change their vote right up until the verdict is affirmed and recorded. They could vote guilty, walk into the courtroom, and at that point change their mind and say, you know what, I think the defendant is not guilty.
Yeah,
So
but you know
again,
what? They couldn't change their mind at that point because they weren't polled. They weren't polled. So no, that's a disingenuous argument because that's not the way we do it in Massachusetts. No, they couldn't change their mind.
like counsel wants to argue, this was a final vote, this was a final decision. You still can't rule out the possibility that any juror was free to change their mind had they been required to go through the full exercise of rendering and affirming a verdict.
Can I ask, is their argument what Justice Sotomayor wrote in dissent in Bluford, or is the different?
To characterize counsel's argument, I think that they are relying on that for the notion of there being an acquittal in substance, not form. Although if you look at the cases Justice Sotomayor cited for that proposition, they're all cases involving judicial rulings. They're not jury determinations. I'm not aware of any federal authority that supports the proposition that there can be an acquittal in substance but not form, or I guess more to the point, says that a state cannot impose the requirement that a verdict be affirmed and recorded. I think, if anything, Bluford acknowledges that that could be a perfectly legitimate requirement where it said, take the defendant's argument here on its own terms. It wasn't a final result, quite apart from the requirement to render a verdict or a judgment. So I think Bluford does support our case, Your Honor. I just do want to emphasize that it's not only just the possibility that there could be a change of mind during the deliberations itself, but even after that.
Is Bluford limited to lesser included, or is Bluford broader than a lesser included opinion?
I don't read it that way, Your Honor. No, I read it as the general proposition that there are multiple charges, whether they're lesser included or not. Jurors remain free to go back and revisit a prior vote. In fact, I think the court said that although Arkansas was an acquittal first jurisdiction, nonetheless, the jury remained free to go back and revisit a prior vote because that's what jurors do. And it wasn't inconsistent with the instructions. I want to emphasize one other point, which is at most, what we're talking about here with these juror statements is a snapshot of the jurors' deliberations, but you cannot short circuit the verdict requirement and rely merely on such a snapshot. And it's important because it protects defendants too. You could imagine a different scenario where a juror comes forward and says, notwithstanding the declaration of a mistrial, we all took a vote and we found the defendant guilty of murder. If the Commonwealth were to come forward and say, effect should be given to that vote, there can't be any serious doubt that the defendant, whether in this case or in a future case, would argue that is not a valid verdict and shouldn't be given any consideration. Unless Your Honors have any other questions, Commonwealth would ask that the defendant's petition be denied.
Okay, thank you very much.
Oh, he just wants to get out of there.
Court, all rise, please.
That's it. He took his 15 minutes. He's like, I'm out of here. I'm done. Unless you have any other questions for me, I just want to go home. That is what the inner workings of the SJC folks looks like, folks. No other attorneys get to speak. There's no rebuttal.
Please exit the courtroom.
The ACLU does not get to speak. The briefs are extensive. The judges read all the briefs before they take the bench, and hopefully they watched the video too. Let's just take a look and see what happens. Court TV had a terrible, terrible video. I don't know if they're done. Yeah, they cut out, but as you can see, the SJC feed, which we initially started to watch, had better video. But the oops, stop talking. It had better video, but the audio wasn't great. And because it was live, I don't think we can watch it again. Okay, so as you can see, they hammered both sides on this. It wasn't one-sided. Everybody started to get a little bit worried when they thought that they were giving Marty Weinberg a hard time. However, as you can see, they do that to both sides because they really want to know their arguments on both sides. They play devil's advocate on both. What say you? Let's go to the questions. Nate was so excited. Thank you for tuning in from Australia. Loves the full panel when the judges ask a lot of questions. Thank you. Thank you. I appreciate your work and your being here as well so very much. So thank you for that. And for your super chat. Kelly Kell, who's arguing for the Commonwealth? Can't be Lally. Nope, that was Caleb Schillinger. He's a Harvard-educated lawyer who handles appeals for the Norfolk County District Attorney's Office. Thanks. The Goodmans are here and they gifted a membership. Thanks, you guys, for tuning in as always. Thank you so much, Clinton Nix. Thanks for covering this. Thank you for your super chat. Tara in Boston, thank you so much for the 50. I appreciate you more than you will ever know. KB, thank you for your super sticker as well. Crypto Taxler, thanks for the 5. Says Gull makes Bev look like strawberry shortcake. Yeah, we were looking for some analogies the other day. Amanda's so glad she's off today. Thanks for the 5. So glad you're here too. I'm losing my voice. Julie loves law. Would an outgoing president be able to pardon Karen Reed? Well, she hasn't been convicted of anything. So there's no conviction. There's nothing to pardon. Thank you, though. Thanks, Jolie, for the 5. Appreciate you. I'm glad you took off work, Amanda, as well. Tracy, I watched Brian Steele before the Georgia Appellate Court yesterday. It says Appetite Court, but I think it was autocorrect. Thanks, Tracy. Romy's so anxious over this. Do you feel better, Romy? You feel better? Because he gave it to both sides. And quite frankly, the Commonwealth attorney, Schillinger, was deferring in a lot of ways, in many ways, to the defense arguments. He can't really argue against that. He can't say, yeah, no, it would have been unduly burdensome for the judge to exercise her discretion and actually poll the jury, actually ask the attorneys if they were cool with her declaring a mistrial, giving them an opportunity to see the note. Camille says they should pause the clock when the judges interrupt and eats up his time, in my opinion. Thanks for the 5. They did actually add time to Marty Weinberg. He got an extra something like 25 minutes. So if they've got more questions, they're going to let him talk. It was Schillinger who at his 15-minute mark was like, oh, okay, can I go? Can I go? Is it lunchtime? Let me out. Shannon, it was making Shannon nervous. Thanks for the super chat. Thanks for the 5. Hopefully I was able to talk you off the ledge. Maura, this doesn't seem to be going well. I think in the end, this was early on, you said this. I think in the end, as the Grateful Dead say, seems like all this life is just a dream. And Pilgrim Shadow is in here every day with the Grateful Dead quote of the day. Thank you so much for that. Sassy Bartender, can the ACLU speak? We're not allotted any time. So the answer is yes, if the court says they can, perhaps. Who knows how they do it in Massachusetts? Your guess is as good as mine, but they did not. They did not speak. Oh, you love your cup. Blessed Mom from Texas won a mug. We did a giveaway one day, and I'm so glad you caught it. Thank you. We're glad you're back. On the up and up, I think I addressed this during the stream. I did not think it was going badly at all. I thought that they were going to hammer both sides equally, and in my opinion, they did. In fact, in my opinion, I think they asked the Commonwealth the more important questions. In my opinion, you can go back and watch it. The replay will be on Court TV. Crypto tax lawyer says, y'all, I know we just voted, but keep in mind judicial elections are important. Judges are just elected lawyers, but can wield dangerously great power from the bench. Delphi, Reed, Koberger. Well, in Massachusetts, the judges are appointed. So in New York, we do vote for our judges. And so you're right. We've been talking about this pre-election, that if you do vote for judges, you should absolutely 100% do your due diligence on researching and finding out what they stand for, what their prior rulings were. Have they ever been a judge? What kind of experience do they have? What kind of lawyer were they? What kind of law did they practice? No, the jury, Holly, was not present today at all. This is appellate court. There is no jury. Good citizen, how about the verdict slips? They have something about the verdict slips. They have not. And the instructions were not that way. SJC, come on. Yeah, they got to argue the law, not so much the facts. The appellate courts are all about the law. Maybe that's why he didn't want to waste time on that argument, but I agree with you. That girl says, thanks as always. How is the jury supposed to know the process and the law? I'm shaking my head. It's like asking them to do root canal with a check sheet. Look, we watched a trial recently and I forget which one it was. It may or may not have been, I think it was the Carly Gregg trial. Was it? When the defense attorneys were asking the judge to charge the jury and explain to them the definition of reasonable doubt. And I believe, you can correct me if I'm wrong, gently, that it was Judge Dewey K. Arthur who said, no, it's common sense. All juries know what reasonable doubt is. And I would submit to you that based on what we've been watching lately in jury trials, that is not actually very accurate. It's just not. So that's my opinion. Having 1 hour for closings in a case that went 9 weeks is also insane to me. There was so much to tie together in closing arguments. They should have been allotted way more than an hour. The Sarah Boone trial, which we just watched together, was something like only 6 days of actual trial testimony, maybe even 5.5 days. And each side was given 90 minutes to close. Yeah, I agree. MLC, thank you so much for becoming a member. Joseph Kane, thanks for hanging in for 2 months. This is what you get with one-party rule nonsense. I don't know. Not going to get political about things today, of all days. God save the Commonwealth. Thanks, Deborah, for gifting 5 attorney Melanie Little memberships. I appreciate you. And to the members who were randomly gifted. Before some of you bug out of here, I just want to let you know I'm going to be covering the Daniel Penny trial at noon. So when I end the stream, it's going to teleport you over to that stream. It's already 2 days in. There's no court today and there was no court yesterday. There will be court tomorrow. Daniel Penny is a 24-year-old Marine who is being charged and on trial right now in New York City for manslaughter and negligent homicide, facing a total of up to 19 years in prison. When a homeless man who was on synthetic marijuana and some other psychotic drugs came into a subway train, an F train, and started threatening passengers that he was going to kill somebody and he didn't care if he went to jail, Daniel Penny put this person in a sleeper hold until the train came to a stop. And the Jordan Neely, the victim, unfortunately died. There was a video shown on day 1 of trial that he had a pulse when law enforcement got there. So this is going to be a very interesting trial on a lot of levels. It is not televised, so I'm going to go over all the testimony, most of it that I can get my hands on that's happened so far, in addition to the opening arguments. Edward Kirkpatrick, so if you're interested in that, come on over, share it out. I don't see anybody else covering this trial, and it's a really important one to me as a New Yorker. Edward Kirkpatrick, Weinberg only failed on the don't write until all unanimous jury charge. Weinberg is great. Yeah, whether that's a question of law or not, that's appropriate in front of this panel, I don't know. And actually, I don't even think that was an argument in the underlying briefs, now that I think of it. We went over all of the briefs. All of my prior shows where we went over the briefs are in the video description if you did not see them. But I do not think that was part of their argument. You can also, as always, correct me if I'm wrong, because there's so many cases that we are conflating, maybe. Mark, thank you for your super sticker, for tuning in from across the pond. Thanks, Jamie, for chiming in with your Massachusetts law experience. Decision from this SJC is usually within 130 days. In this case, it'll be sooner with upcoming dates, she is imagining. And we will say there has just been a motion made by the Commonwealth to adjourn the January trial date to April 1st. April Fool's Day. Is that fitting or what? The defense has consented to it, but again, Judge Bev has the discretion here. So there's a lot of kind of misinformation circulating out there on the Twitterverse and the cesspool that the trial is moved to April 1st. That has not been ruled on yet. We don't know if she's going to agree to that. Clinton, no frosting on your cupcake if you complain about my commentary. Thank you very much. Thanks for the 5. The Goodmans are here. Thanks, Goodmans, for the 10. I appreciate you guys. David Reese, the birthplace of the Constitution is Philadelphia, not Massachusetts. Thanks for correcting me, David. The birthplace of our nation was, Plymouth Rock. No, was it not? Is Massachusetts not the cornerstone, the bedrock, the rock of our nation? It's just ironic, don't you think? A little too ironic. Yeah, I really do think. Glamma, thank you so much for the 5. Plevin has been emailing and contacting an alternate juror at a non-public email and threatening to expose her. I don't care about him at all, but thank you for your opinion and newsflash. And I don't know. I don't care about him. Edward, thanks for the 5. Mistrial is not final either by his argument, unless Judge Bev polled them individually as to whether they were unwilling to change their vote. Correct. And she didn't, right. I think I said that, right? During. Kathleen Potter, thank you so much for the $50 super sticker and for being here. Thank you, Kathleen. I really, really, really appreciate you and your generosity so very much. Lizzie Dalton. Hi, Lizzie. Missed you. I have jury duty soon in the famous court. Oh, really? You're wearing your One Saying You t-shirt. Why not? That is a very, very ancient court phrase. Thank you. So you have jury duty in Norfolk Superior? God save the Commonwealth, Lizzie. God save the Commonwealth. Romy, anyone else have the legend of Billie Jean, fair is fair, going through their head, or is it just me? That did not come into my head, Romy, but I do often think in song lyrics. And Kathleen Potter with another $50 super sticker. You're amazing. Thank you so much. I appreciate you. Like, you have no idea. Michelle, thank you so much for coming in with the super sticker. I did not watch the Melody Farris trial. I didn't watch it because we were covering, I think, Sarah Boone at the time, and then I got into Delphi. So what did you guys think of the Melody Farris judge? I don't know. I have zero opinion. I can't watch it all. I can't. I know I want to, but I can't. Thank you, Jessica, for hanging in for 5 months and says she enjoys watching me the most. I appreciate you so much. So the arguments that both sides were kind of hammered on, I think, were what we expected. And based on their questioning today, I really have no idea which way they're going to rule. There were some, isn't it true that this is not the way we do it in Massachusetts type arguments? And then it was like, do you have any federal cases to stand for your precedent here? This is the case of first impression. This is the case of first impression in Massachusetts. And sometimes you have to be brave enough to change the law. And it would be as simple as just in the judge's handbook, because they all have a handbook, believe it or not. There should be something perhaps that says when there are multiple counts and the jury tells you that they are deadlocked, you must inquire. And they said that is in the notes of Rule 27B. I think the notes say you may inquire, but I thought, or in the rule it says you may inquire, and then in the notes it said you must inquire, and they had a lot of questions for Schillinger on that, on whether or not she should have inquired, and it's really kind of simple when you boil it down to just that, right? In my opinion. Thanks, U.S. Marine Corps Cowgirl Semper Fi. Thanks for gifting a membership. I appreciate you so much. May or must, right? That was the question. And then they kind of were leaning towards what's the harm in asking? Right? What's the harm? No harm, no foul? Stephanie says Melanie Ferris was a hoot with Miss Martha Jean. If you know, you know. Yeah, that isn't that Recovery Addict was covering that trial, and he said something during the trial about the murder weapon or the gun, and then Miss Martha Jean like called the court or called the attorney or called somebody and said, I was watching this little man on the bottom of my screen and he said something about the gun and it reminded me. You guys can probably summarize it better than I can, but it was Recovery Addict to the rescue. And then this woman called in and then she became a witness in the trial. I don't know. Hi, Maria. Why are they so obsessed with this case? Any sane person can see she's not guilty. Evidence shows it. For me, it was about the injuries. From the beginning, when I started learning about this case, it was about the injuries to me. I have 30 years experience. I am not a Timu lawyer, as surmised by some of the Twidiots. 30 years experience with civil litigation, including not just cases against the Catholic Church for clergy SA of many, 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 many children, car accidents, dog bite cases, all kinds of things like that. And what struck me immediately about this case is, and I was waiting for it, where are the injuries to the knees, the legs, the hips, the thighs, the bumper marks? They never came. There weren't any. That's the answer. There weren't any. That's impossible in a pedestrian versus car motor vehicle accident. It's just impossible. Oh, I'm glad your nerves are better now. And so that's what stuck out to me initially. It was all about the injuries for me. Everything else is icing on the cake. I don't know why it's so hard for people to see that. A car doesn't just hit your arm like this, and then magically the taillight explodes into these, shapes that look like dog teeth, and then all scratch your arm at the same time through 2 layers of clothing, propel you 30 feet into the yard, smash your head, and you have no injuries to your lower body. It just doesn't, it's physically impossible. It's physics. It just doesn't happen. Thanks, Deborah, for becoming a member. Well, thanks, Gem Girl, for coming in. I'm glad I showed up on your YouTube today. Do you think this hearing is in favor of Karen? Bonnie, I am not a betting person, and I would never, ever, ever bet on what a panel of judges will do, just like I will never bet on what a jury will do. You never, ever, ever know. Has to, it's all going to come down to, are they willing to change the law? Are they willing to make new set precedent? Because this is something that's unprecedented in Massachusetts. They've never had a case like this before that is directly on point. And so that's what it's going to come down to. And the fact that they were asking for federal case law is good. But, if you try to ever squeak in a federal case into your motion papers in front of Judge Cannoni, she would be like, well, I don't care. That's not the way we do it in Massachusetts. I want to show you guys something because I thought it was so funny. Those of you guys who have been following trial coverage with me, tell me who you think this looks like. Hold on. This is something that somebody sent me from Twitter last night, but look who's standing behind. Do you see this man right here? Who does that look like to you? We have an emoji for that. Is that Robert Tellis, Boss Baby? Did somebody give him a day pass from prison? How did he get there? Was he pardoned? What is going on? Tell me that's not him. What is he doing at the victory party? What? It's crazy, right? Uh-huh. I thought that was insane. I'm like, did somebody fly Boss Baby in from Tellis? Did they give him a day pass from prison to come to this thing? And now I'm looking through here. I'm like, where's Ashley Benefield? Because remember, That's where she met Doug Benefield, was at Mar-a-Lago. I'm like, is it Ashley Benefield here too? Is it like, I thought that was so crazy. So crazy. I mean, does he have a twin brother? Because that I just thought was crazy. I miss Boss Baby too. And I was like, wow, that is crazy. Oh, and somebody said, Robbie said his hands are too big for Tellus. Oh yeah. And I think he's too tall also, but I wonder if he's wearing those little moccasins. Those little moccasins. That was last night at Mar-a-Lago, because in the forefront of the picture, it looks like it's Trump and Elon and Joe Rogan. And it was around the time that the electoral map said Harris 91, Trump 195. I don't know. This was just something that somebody sent me, and I thought that was crazy. But I thought, yeah. I don't see that the face is superimposed. I just think it's a guy who looks a lot like him. And it struck me. Yeah, too tall. Too tall. Is he wearing his cheap Marshalls plastic Nike sneakers? I don't know. Thanks, Deborah, for becoming a new member. Thanks, David, for hanging in here for 5 months. You're always a welcome contributor. Time flies. Thanks, GP, for being here for 6 months. Joseph, thank you for your super sticker. And Camille says the Commonwealth stumbled when the judge asked if the Fifth Amendment is more important from the rest. Yeah. Yeah. I mean, the argument's just a little bit weak, in my opinion, from the Commonwealth. We all have a doppelganger. We all have a doppelganger. Oh, Fairy Raven, thank you so much for the matcha latte. I'm going to need a lot of that today. And also, Barbara sent me $20 for coffee. Thank you, Barbara. Thank you, Barbara. I thought it went really well. I think Schillinger's an excellent lawyer. Listen, he went to Harvard. He's no idiot. But like all lawyers, you deal with the set of facts and circumstances and the case that you have. And he did his best. But I think when I heard that judge say at the end of Schillinger's 15 minutes that he wanted to run away from and not extend his time, when he said, or she said, isn't there public interest in the truth? Don't you think the public deserves to know the truth? Finally, someone in Massachusetts sitting on the bench thinks that it should be about the truth instead of a conviction. I don't know when the decision is coming out. Some practicing Massachusetts attorneys say it can take up to 130 days, but it may be faster than that because, you know, they got to get the criminal trial moving, even if it is adjourned to April 1st. That's a good point. Is this move only going to cause Bev even more insufferable in round 2? To be even more insufferable in round 2. Her bias was already evident, but will she be even worse in round 2? We don't know. We don't know. She may be rotated out of there. We still don't know whether that's accurate or not, that she's absolutely not being rotated out of there. I think they had a big, huge public relations crisis that week when that story broke about perhaps she's going to be rotated out of there and not on the second trial. And they had to quickly come out and squash that rumor because the PR people were working overtime. And didn't their spokesperson just also quit that week? And didn't all of the better bombs drop? And now all the special prosecutors are under fire. You got Tully under fire, Mello under fire, confidential informants out there bragging about their confidential status and personally texting Ken Mello and Tully about, you know, what time somebody's bus gets there so they can serve him with a subpoena and, you know, what's going on and maybe framing people for witness intimidation, like insane stuff. It was all that same week. And who knows if they wanted to actually squash the rumor quickly. Michael, does the public have an interest in the truth? They can't handle the truth. They can't handle the truth. What am I drinking? Iced coffee. Iced coffee. I love when people come in like an hour into the stream and they're like, hey, I'm late. What did I miss? Do you guys catch them up, or are you just like, start from the beginning, go on 2 times speed? Except you can't put me on 2 times speed because I speak at 2 times speed. See, Bridget says, Bridget, voice of reason, the SJC is about the truth. The lower courts want a conviction. That is right. Oh, thanks, Holly. It typically takes up to 130 days, but it may be quicker in this case. I'm sure that they will issue a very well-reasoned, long written opinion because this becomes the law of the state of Massachusetts. Case law, common law. This is how it's done. Hi, Kelly. I love that line also. Oh, the one about, yeah, don't we want to know the truth? I thought it was great. Kelly, you were there, right? Were you in the courtroom? How did it go for you? How do you think it went? I thought it went great. I thought they were equally harsh on both sides. I think Marty Weinberg got interrupted more, but because I think they knew what all of his points were and they just had specific questions. You know, they read everything ahead of time, so they're well versed on the case before they come in and sit down at their big giant seats. Romy says, I think the guy in the picture is Walt. I don't know who that is. Walt Nato. I know I need better letter number 4 too. I said to him the other day when we did a stream together, I'm like, when's the next letter coming out? I think I said it off the air. Anthony says, so if she was acquitted for counts 1 and 3, how in the world would they try her for count 2? Same way they tried her for the first 3. Same way. Oh, thank you, Patty Murphy. I was watching someone else that I enjoy looking at, but realized I was missing out on substance. Thank you. I appreciate that. Common sense is not very common. We are unfortunately finding that out. Is Kelly still here? Because she can tell us what they think, how they think it went. Christy says, watch the verdict of Quentin Tillis that was accused of killing Jessica Chambers here in Mississippi, and you'll see the importance of polling a jury. Yeah, they do it. Yeah, Kelly, what does Karen's team think? That was a great day. I was glad that AJ flew in. 5 o'clock shadow and all. Do I think any of them watched the trial? Your guess is as good as mine. They're not required to rule on this. I don't know how much time really that they have to go and watch trials when they're, working. I don't know. I've already brought this up once, but I'll say it again. He never brought up the judge's crazy and confusing instructions. That's a fail. But they're here to discuss the law. And that's more of a fact. And so, could he have brought it? I don't know if it was in the original papers. Know what I'm saying? Scott, I don't know what you're trying to say to me. Bice is like, forget it. I get tired of rehashing it. For those who came in late, not trying to be mean, but some cases are complicated. Please watch the replay. Love. Hello. I know. I'm waiting. I'm waiting too. Waiting for letter number 4. Thank you. Something is so funny, Karen Reed. Hello. Grant was there being mean and causing problems with Karen and Turtle Boy today. I think I'm going to stay out of all the side drama. You guys can go watch it, but it was a Tom CPU who was streaming live. Dana says, well, when asked if there was federal precedents, Weinberg should have said, well, the federal, the Bill of Rights is federal. Let's see, what do we have here? If Kelly's still here. Thank you, Joseph Kane. Priceless. Yes, no, that was absolutely, I don't know if it was some scruff or just a shadow, just the 5 o'clock shadow, but I actually did pause it and told you guys to come back to the screen in case you wanted to see it, so you can go back and look for that. Pause game on point today. Turtle Boy interviewed Brennan. Hank Brennan, really? We'll post soon. Okay, cool. Maybe it's No Shave November. That's exactly what I was thinking. I'm like, what do they call that? Movember, November, No Shade November, No Shave November. Maybe could be. We all just want the facts. Nothing else matters. Nothing else matters. I have not done a stream with Turtle Boy because he's got criminal charges pending. I'm an attorney. I don't want to bring him on my show, potentially ask him some questions that he answers and may, implicate him in his criminal case. After his criminal cases are over, welcome. He's welcome to come on. But as an attorney, I just don't think that's a very responsible thing for me to do. I wouldn't want to put anybody in that position, I don't think there are any Supreme Court justices in the chat. Hi, Kelly Reed is here. She says he does have a beard. He has a beard. How's everybody feeling? Are you guys going to go have like some mimosas or something? Oh, thank you, Kendra. I love your insights as the arguments are presented. Thank you for your experiences and insight. Thank you so much. He's had it for a while. The facial hair. Magnolia Gypsy. I'm ignoring the side drama. I was watching trials before, and I will be watching trials long after Karen Reed is acquitted or the charges drop. No one creator has that market covered. That is 100% correct. You are correct. Hello, Ms. B. Where do I think it goes from here? I think that we wait for a decision on this. I think that the appellate court has made it kind of clear that they're not just going to acquit her of those 2 counts based on the first questioning of Mr. Weinberg. I think that that's out. And the focus was more on why should we question the jury and why should we bring them back? And we'll have to wait for a decision on that. So if they agree that the jury should be called back in and questioned, simply a yes or no question. Did you agree to acquit on count 1? Yes or no. Did you agree to acquit on count 2? Yes or no. Count 3. It would go back to Judge Cannoni for that hearing, unless for some reason she's a potential witness at that hearing. And then that judge would render a decision on whether or not to acquit on counts 1 and 3. And then that decision could be appealed. So it's hard to say. We're in the land of upside down here. We are in the land of upside down. Thank you so much for not questioning my high morals and ethics, or whether I'm really an attorney who's spewing misinformation, Jody Mitchell, like whoever that llama woman is in the cesspool of two idiots, who thinks that I'm wrong by saying that Karen's civil attorneys can third party in defendants who they think are actually liable. Not guilty. I never said guilty, because you can't be guilty in a civil case. You might be liable in the death of Officer John O'Keefe. And if you think that's not actually real life, maybe you should go study some third party defendant rule in Massachusetts, whatever they call it there, but it's commonly done, and it will be done. Mark my words. And then you can just go off of Twitter forever. Stace, thanks for the 5. For me, it was Brian not coming out of the house. Why is every judge, DA, police, and or politician acting so incompetent? Love this chat. Thank you, Stace. We love having you in this chat. Sounds like a rhetorical question. And it's not every judge, every DA, every law enforcement, because, we back the blue 100% here. At least I do. But nobody hates a bad cop more than a good cop. We can't lump everybody into one category. Thanks, Cats Meow, for being here for 6 months. Free Karen Reed, she says. All right, my friends, any final thoughts, questions, concerns? Thank you, Paul, so very much for the Venmo. I appreciate you. I'm going to come back at noon. We're going to switch gears and we're going to go to talk about Daniel Penny and what's happening in New York City. Let's see if Kelly put anything else in the chat for us. Smash the like button, please. It helps the algorithm. Share the stream. Do all the YouTube-ish type things that YouTube likes. All right. You will be teleported over to the noon stream if you are interested in hearing about Daniel Penny and what's going on in that case. And we're going to talk about that. So, people keep asking the same questions. So just go rewind. Thank you, mods, for keeping it classy today. I don't know how hard it was in the chat. There was well over 5,000 people in here at certain points. And who knows? Hate watchers, we don't know. The trolls come out on days like this, you know. They just do. They just do. They just appear like evidence. They just do. So thanks, mods, for keeping it classy. Appreciate you guys so very much. Do all the YouTubers things, my friends. Thank you, Cupcakes, for being here and discussing this with me today. It only took us 2 hours and 10 minutes. And we did do a lot of questions and we did do a lot of chit chat. So buckle your seatbelts. I'm going to teleport you over to the noon stream and, you know, be cool, be kind, be classy. It's not hard. It's really so not hard. Stay out of the drama, my friends. Stay out of the drama. Your life will be so much better for it. I promise you. Smash the like. Peace. I'll see you at noon Eastern.